The information made available via this podcast is for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this podcast or any of the email links contained within its website do not create an attorney-client relationship between Michael Dockins, Shoemaker, Loop, and Kendrick, and the user or listener. The opinions expressed at or through this podcast are the opinions of the individual author and may not reflect the opinions of the Shoemaker firm or any other attorney.
Hey everybody, it's Mike Dockins, the Gimmick attorney, coming to you with another episode of Wrestling with the Law, episode 8, a mostly monthly show on ad-free shows, bonus content for you. Sorry about June, got tied up, just lost track of time, celebrating Conrad's birthday and life and all those things. And frankly, I was able to take advantage this month of, how do I put it nicely? We'll just call them by their official title, the summer law clerks at the firm, to be able to pull off some research for me so I didn't have to do it by myself, to be able to help bring this episode to you. But in any case, again, this is Mike Dockins, partner at the law firm of Shoemaker, Loop, and Kendrick. I'm based in Northwest Ohio, but we've got offices all over God's creation. We're in Tampa and Sarasota. We're in Charleston. We're in Charlotte. Look us up, shoemaker.com. Anyway, today's topic, we're going to talk about the case of Mattel versus Azrak Hamway International, also known as Remco Toys. The reason I kind of decided to pick this one is that Remco and Mattel, as you know, make wrestling action figures. And recently on ad-free shows, there was some bonus content this week hosted by a friend of the show, Lauren Yaffe. And she had on Zombie Sailor, who creates and has... he's revived a toy line, the retro action figure toys, and has signed our very own Jeff Jarrett. And he's actually bringing to life a Hasbro action figure from the 90s that never got made. It was supposed to get made. It was designed. They had the drawings, but the toy line died and it got canceled off before Jeff's action figure ever took off. And Zombie reached out to Ron Rudat, who is the artist who did the drawings, the old school way of preparing action figures and making it so that people could see them and then get sculpted and then made. He's worked with Ron to get Earl Hebner and any number of other folks and friends of the show and friends of Ad Free. But Jeff is getting his actual Hasbro, what it should have looked like. So Lauren and Zombie were on with Matt Cardona, also known as Zack Ryder, and Brian Myers, also known as Kurt Hawkins. And they were talking about action figures, and they were talking about Jeff's action figure and the San Diego Comic-Con exclusive that is that figure. I think its pre-sale opens maybe the 26th, July 26th, the 2021. So, get out there and support Jeff and support Zombie and those guys. They're doing some really fun things. But in addition to that, and watch for that show on Ad Free, it's not up yet, but it will be in the coming weeks. Brian and Matt and Zombie actually himself are clients and friends of mine as well. And they're really good guys. And so I hope you guys support them. In fact, I'm going to ask you to do me a favor. Matt and Brian and their co-host, their producer, Smart Mark Sterling, have their own podcast network, and they're building their own thing. And they've done some amazing stuff, really about toys. I was a little reluctant to sign up for it, but I wanted to support them when they first came on as clients. And so I signed up for the Patreon and really started listening to the pod. And because of them, now I feel like a kid again and have found joy in collecting certain action figures and things. And behind me, you can't see it because of the screen. I've got every Andre the Giant action figure that's ever been created, at least, one version of it, if not two, sometimes mint and packaged, sometimes loose. So they really, that kind of addiction, I blame those guys, but they've got a network on YouTube, the Major Pod Network, and they are trying to get their subscribers over 100,000, and they're really close. And so if you guys could stop real quick and head over to YouTube and sign up and subscribe to the Major Pod Network account, that'd be great. Help those guys out. They deserve it. And while you're there, stay for some of the content. Cause like I said, I wasn't really that into it until I started listening to it and hearing those guys and how excited and how infectious it is when they talk about action figures and collecting. It's really cool. It's really fun, and it's interesting. It's interesting to hear a lot of the history that when you think about toys, you might not think that would be that interesting, and that the artwork that goes into it and things getting canceled and changed because of disagreements with the company and that sort of thing. It's really, really interesting. So while you're over there, while you're at the major pod network and subscribing to those guys' channel, look and watch the history of Wrestling Buddies, the stuffed animal kind of things you might remember. That's very interesting. They had the designer and the originator help out with that episode. There's also an episode with the Podfather himself. Conrad appeared with those guys a while back and talked about the history of LJN action figures. The LJN action figures, you might recall, they're a little taller, kind of Barbie height, maybe a little shorter, but kind of rubber, not a hard plastic. They went through and talked about all those, but they also did a history of the Hasbro action figures, which is what the Jeff Jarrett action figure I just mentioned is kind of modeled after. And that one, I want to say that's like a 4-hour episode, so you might not be able to sit down and listen to it at once. But again, I found it just utterly fascinating, the iterations and how certain body parts get reused and repainted and this sort of thing. It's really interesting stuff. So go check it out. And if you don't know what the Hasbro action figures are, I thought I'd pull one in my own collection. In addition to being Andre the Giant, Mark, I'm also a big Rockers guy. So if you're watching this on video, here's the Rockers Hasbro figures from my own collection. So that's what those look like. And that just brings back, to me, that's right in my wheelhouse when I was a kid. We didn't have a lot of money or anything like that, so I didn't have a lot of action figures. In fact, the only Hasbro I had growing up was a Jake the Snake Hasbro, because it was the only one that was available, as I recall, at the toy store. The rest, the Hulk Hogan's and all of that, were sold out. So it's been fun to kind of get some of those things that I didn't have a chance to get when I was little. So anyway, to the case at hand. The case at hand involves Mattel and Masters of the Universe, He-Man as it were, and Remco. And Mattel had sued Remco, saying that they copied their He-Man, their Masters of the Universe figures. And we'll pop up some figures, some images of those figures right here, right now. So if you're watching on video, you'll see it. But the first picture, the first image will be a He-Man, something from Masters of the Universe line that Mattel owned. The next one that'll pop up will be a character from the comic book, the Warlord. And so it's a Warlord character, and it was made by Remco. And the last one we'll bring up, so we can tie it into wrestling, Remco is also really known for making their He-Man action figures, their He-Man wrestling figures. And this is a Rockers one. And so the last picture we'll bring up will be a side-by-side comparison of all three. The lawsuit really just involved Masters of the Universe and the Warlord character, not Warlord the wrestler, but Warlord the comic book character. It involved those action figures, not the wrestling action figures. But because of this lawsuit, the wrestling action figures weren't a problem, able to run wild with them and do whatever they wanted and make them look however they wanted. And so this is a representation of it. Look at all three. You can see if you're not digging into the detail of it, if you're not digging into the minute areas of the law about what Mattel was complaining about, you might say, wow, those look like they're made by the same folks. And frankly, I'd agree with you. But we'll get into the case law a little bit and how the case was decided and what was decided. And you'll see, well, maybe it's not so close after all. So the facts of the case: Mattel, a well-known toy company, manufactured a series of 5.5-inch action figures sold under their registered trademark Masters of the Universe. So the court found important facts that it's a series of dolls. It's not just one particular doll, but all these different Man-E-Faces or Man-at-Arms and all these things. This is a series of dolls. They had different heads, they had different clothing, they all had their own names, but they all shared a common torso. So not the arms and legs and the lower section, not the head, but just the pecs and the abs. That was a sculptor's quote unquote exaggerated rendering of a bodybuilder's body, but with shortened legs. So that's one of the facts of the case. Another fact was that Remco similarly created a series of 5.5-inch action figures for the Warlords or the Warlord comic book series. It's a series of dolls that share a body with overdeveloped musculature and legs that are proportionately shorter than the average human being. So same thing, exaggerated muscles, short legs. Similarly, the Warlord line, they all had names and heads and hands and their clothing that were different from each other, but different from Mattel's, with the names of the characters and the costumes and all of that bearing no similarity, no resemblance whatsoever to the Masters of the Universe. Instead, it was all based on those certain comic book characters. With respect to the bodies of the Warlord characters, the courts found and found a factual statement that the bodies all had pectoral muscles, abdominal muscles, and other musculature that differs in minor ways from the Masters of the Universe, but they were significant details and differences. So again, if we bring back this picture again of the comparison of all three, you'll see, if you look at the abs and the midsection and the pec muscles and all that, there are differences. There's different striations and this sort of thing. The court found, factually speaking, that both dolls are posed in a similar crouching position. And there's another fact that Remco, on its packaging for the Warlord action figures, used the phrase "play with these" and at the same time as Masters of the Universe figures and other 5.5-inch figures. So the Masters of the Universe trademark was on the packaging for the Remco Warlord figures, which Mattel had a problem with. So what happened? Mattel went to the courts in the second district court and sued them for copyright infringement and trademark infringement. And they sued them in New York. And so what they were trying to do is get an injunction. So they went to the court before they really got into the meat of a copyright infringement claim or a trademark infringement claim. They went to the court and said, hey, they're about to fire off all these action figures, and their molds are ready and the plastic's ready, and they're pouring them and they're just going to start selling them in the US, and you need to enjoin them. You need to get them to stop from doing that because that's going to compete with us and our Masters of the Universe, and they're using our intellectual property, and that's not fair. Mattel said, look, both of us have these dolls that have very similar torsos and very similar crouching positions, which I'm not sure if it was them or the court likened that crouching position to the fighting stance of a Neanderthal man or a latter-day professional wrestler approaching his opponent. I guess that's one way to describe it, but it's funny to me that talk of a toy in that language, the fighting stance of a Neanderthal, is as though any of us know what that is, or that of a latter-day professional wrestler approaching his opponent, appeared in court documents and legal proceedings. In any case, what the district court found was that any claim of uniqueness in that pose is frivolous. It's just nonsense. There's nothing protectable about that particular stance and how their legs are aligned and configured. So the circuit court, agreed with the district court that Mattel did not demonstrate. I'm skipping ahead. Mattel lost is the short answer. And then they went on to appeal it and say, hey, we shouldn't have lost. We should have got this injunction. And the appellate court then said, nope, the lower court was right. Mattel, you lose, and Remco, you can keep doing what you're doing. But both courts found that Mattel didn't demonstrate a substantial likelihood of success in proving any sort of infringement with respect to the torso or with respect to the trademarks. And that's why it kind of got summarily dismissed. But the district court had reasonably found that the only parts of the doll's bodies that constitute a protectable expression of idea are not substantially similar. So what the courts did is looked at the dolls side by side and kind of started removing the things that could potentially be protectable. And when you take away those things that could potentially be protectable, the face, the head, the hair, clothing, accessories, things like that. Once you take all that away, what you've got is things that either aren't protectable, or that if they are, they're not similar. They're not substantially similar, and therefore there's no infringement. There's not an issue here. The court found that the particular arrangement of musculature in the Masters of the Universe models hadn't developed secondary meaning consumers' eyes, so that when consumers, what that means is it's not inherently a trademark, the torso, the torso portion of a He-Man. But if it was so unique and so different from anything anybody else had done, that if a consumer were to come up and not see the packaging, not see the head, not see the arms, not see the name, that sort of thing, if they just saw the torso, they'd say, oh, that's from a Masters of the Universe figure. That's from a Mattel figure. That's secondary meaning. If you think about a Coca-Cola bottle, the glass bottle, even the plastic ones, the ribbed sort of shape and all of that, that's a very distinctive trade dress. And when you see one of those bottles, whether or not you can see the trademark, if you 50 feet away, it's 20 feet away in a room, and the label's not facing you. If you see that bottle and you see that shape, you know that that's a Coca-Cola bottle. There's secondary meaning in the bottle. A bottle by itself and a bottle shape is not inherently a trademark. And is not inherently a source identifier. But if it gets to be so well known by the consuming public to be able to say, yeah, I know who that is. I know what company that is. I know what product that is. That's secondary meaning. And the court said there's no secondary meaning in the He-Man torso. Another trade dress, things you hear about is, like a Taco Bell. If you see the shape of a Taco Bell building, sometimes they go out of business and they get picked up by a local burger place. Like, that used to be a Taco Bell. I can tell based on the roof and the orientation and the size and the shape of the building. That's secondary meaning. The district court also found that the use of Masters of the Universe on the Remco packaging was okay. Because it wasn't use that was trying to direct people or confuse people about, hey, this is a Mattel product, this is a Masters of the Universe product. It was just used to describe to purchasers its own Remco products and didn't constitute a bad faith effort to deceive consumers. What this is called is referential fair use. So you're allowed to use the trademark of other people on your own packaging. So, Brillo pads, the kind of rough side and the sponge side, whatever, I can have that version, a version of that same product where I've got a soft sponge side and then a more abrasive side on the other. I guess those are Scotch guards, not Brillo pads, but a Scotch guard pad. I can make that and I could call it, Mike's cleaning pad, and that's okay. But Mike's cleaning pad doesn't mean anything to anybody. So they might want to know, well, what is this? What does it do? And I can put on my packaging, compare to, similar to, use like a Scotch guard pad. And that's okay. That's allowed because I'm referring to and educating customers. Hey, this is a comparable product. It's a comparison is why I'm using it. I'm not trying to make it look like this is, the Scotch guard or whatever the hell it's called product. And so long as you do that in such a way that the trademark you're using of the third party isn't larger or more prominent than your own trademark, that's fine. Nobody can stop you from doing that. So if AEW wanted to, on their shows, have commercials, hey, check out our new AEW show on AEW Dynamite. It's a lot like WWE's Raw, Monday Night Raw, but we think it's better. Like, they could do that. They could have advertisement that said, check out AEW Dynamite. It's a lot like Raw. They don't want to do that. They want to stand out and differentiate themselves and be different from Raw, but they could do it if they wanted to because it's referential fair use and it's allowed. So what the lower court said was, yeah, Remco, what you've done is fine. You're allowed to do that. Mattel is, or at the time of the hearing, the district court, the lower court hearing, were already selling as many of the Masters of the Universe dolls as they could possibly find, or produce, I should say. And for inadequately explained reasons, the court said Mattel delayed, pronouns, pal, delayed bringing their lawsuit, their action until just before the start of Christmas sales season. So the court didn't like that. The court said, look, you did this, you filed for this injunction, not because you were trying to help yourselves or prevent yourself from being harmed. You're doing it to harm Remco. And injunctions and things like this, when two parties are way down the line, courts are very reluctant to grant an injunction because they'll say, look, this can be fixed by money. This can be fixed by damages. We'll give you a royalty. We'll give a royalty, or we'll have you disgorge your profits or something like this. But we're not going to run the risk of really harming you by forcing you to stop right now and then find, you know what, they actually weren't doing anything wrong and let you have to pick back up. So this was so far down the road, and the timing of it was rather inexplicable. Mattel was making money hand over fist on He-Man figures and Masters of the Universe figures, that to wait before Christmas, just before that season, to go after Remco, the court said, nah, we're not going to allow that. So even if you had something on the merits here, even if your intellectual property claims were good, we probably still wouldn't grant this because this can be fixed later. And this is a little too slanted for our liking. So anyway, Remco won, Mattel lost at the lower court level. So then they appealed it. So what happened on appeal? Well, Mattel appealed it to the U.S. Court of Appeals, the Second Circuit. And what they claimed, similarly, like they claimed at the lower court, it's kind of a rehashing of the issues, was that that the producing and the selling of the Warlord's dolls by Remco infringes on Mattel's copyrights and the Masters of the Universe dolls, particularly the torso, but the dolls in general, and its federal trademark rights in the Masters of the Universe trademark, and its common law rights under New York law to be protected against unfair competition. So each state has unfair competition laws or something similarly named, or at least similarly effective. And what those laws are is, hey, trademarks are essentially unfair competition claims. They're saying you can't do this. What you have done is unfair. You're cheating in business, and so it's whether by causing confusion by using trademarks or by using similar copyrights, things like this. What you're doing isn't allowed. It's unfair competition. The state of New York doesn't allow it. So they tried that, and they tried to get the appeals court to give them an injunction. Well, to have an injunction, you have to show a couple of things. First, you have to show irreparable harm. And second, you have to show either that you are likely to be successful on the merits of the case, or that there are sufficiently serious questions going to the merits to make it a fair ground for litigation, and then a balance of hardships tipping decidedly toward the party requesting injunctive relief. It's a lot of legal mumbo jumbo. I get it. But basically it's saying that there's real questions as to the merit, and that if you balance the hardships, hey, if it's worse for us than it is for you, and we're the ones who are asking for injunction, we have to show that, then that's the second prong of the test. But it's a two-prong test, and they have to give us both prongs. So what do the courts say on the copyright claim? The court said, well, Mattel, you didn't demonstrate substantial likelihood of success in proving infringement on the Masters of the Universe torso. What was their reasoning? Mattel said the court said Mattel needed to either produce proof of direct copying of the Masters of the Universe torso, or that Remco had access to the Masters of the Universe torso, and that the protectable features in the Remco's doll's body are substantially similar to the Mattel's body in the eyes of the average lay observer. The court found, and their reasoning was that the design was just two different artists' rendering of a human form with exaggerated musculature. It was a similar interpretation because the human body looks like what the human body looks like, and if you're trying to have crazy musculature and make people look over the top superhero in one instance, well, I guess in both instances that's what they are. They're superheroes. They're fictitious characters. And so the court said, yeah, it's just two different artists. There's only so much you can do with it. And it was each artist's particular rendering. The court further found, in respect to the copyright claim, that nearly all of the similarity can be attributed to the fact that both of the artists that made those torsos or those renderings for Mattel and for Remco stem from the same unpredictable idea. That is a superhuman musculature, muscle man crouching. And again, we see this language in what since Neanderthal times has been a traditional fighting pose. And the rendering of such an idea is not in and of itself protectable. Only the particularized expression of that idea, for example, the particular form created by the decision to accentuate certain muscle groups relative to others, can be protected. So where you have the striations and where you have certain curves or this sort of thing, that's potentially protectable. But the general idea of big muscles and certain number of abs and pecs and this sort of thing, that's just not protectable under copyright law. And they cited another case, Ideal Toy Corp versus Fablu Limited. We won't get into that, but it was a case about a couple of different companies that had similar dolls. One good doll dedicated to younger kids and one doll dedicated to preteens. And anyway, it's not the first time that the courts have had to talk about toys and the toys' bodies for that matter. So the court further found that the only parts of the doll's bodies that constitute the protectable expression of an idea just weren't similar. Because they're not similar to the ordinary observer, no likelihood of success on the merits, no copyright infringement. With respect to the trademarks, what the court held was Mattel didn't show that Remco copied any non-functional design features of the Mattel doll, which had developed a secondary meaning in the eyes of consumers so that the consumers would be misled. So that goes back to that trade dress secondary meaning. could you see the torso? Would you see the torso and say, oh, that's Mattel? That's for sure Mattel. No, they didn't. They didn't prove that. They didn't show there was any secondary meaning. So with respect to a kind of a trade dress perspective, no likelihood of success on the merits. With respect to using the Masters of the Universe trademark, the court said, yeah, of course, Remco is allowed to use the registered trademark to describe aspects of their own goods, even to indicate that one's product is a legitimate copy of another's product. So not that the court was saying that Remco figures were copying He-Man, but they were saying that it's okay to compare them and say, hey, these are comparable. These are the same. You could play with them all together like they're in the same universe, and that's okay. That's allowed by the law. The reasoning on the trademark claims, couple-fold. The dolls have different names, they have different clothes, and they have different heads. So all those sorts of things that you might tie to, oh, that looks like He-Man's head, so that's confusing. That people are going to think that this Warlord character with the He-Man head is actually a Master of the Universe doll. No, those things were all different. No secondary meaning, no identifiable portion of that, so no claim. Mattel also provided insufficient evidence to say to consumers that Remco dolls were being mistaken for Mattel dolls. There was no actual confusion. Nobody was believing those to be the same line from the same source. And Remco's purpose, the court found, in using the Masters of the Universe trademark was to sell its dolls to describe to purchasers a use of its own product. Hey, use our Warlord doll, play with He-Man dolls too. You can put them in the same universe. That's okay. And it didn't constitute bad faith. They didn't do anything wrong, and they weren't deceiving anybody. So in conclusion, the court found Mattel failed to satisfy either prong of the preliminary injunction standard. They didn't show that there was a likelihood of the merits, and there was no hardship. They weren't harmed. They were, in fact, pumping out Masters of the Universe figures as fast as they could get them out there. So no success, and away this case went, and along went Remco until they went belly up. But for their time, they put out a lot of wrestling action figures, and they put out Warlord figures, and some people will say they're knockoff or generic He-Man. That's fine. That's one way to describe it. They certainly did something similar, but it's not the same product, and there was nothing illegal about what they did, and so they were able to do it and move on their merry way. So that's it for this episode. That's it for episode 8. I will be back with episode 9 next month. I promise. I'm going to take advantage of these wrestling interested summer clerks that we have that can do some research for me and do some of the legwork so I can put together the episodes, and we'll keep some hopefully interesting stuff coming at you. If you've got any questions about Remco's or Mattel, I'll try to answer them, or about this case, happy to try to answer those. If you've really got action figure questions or trying to figure out something there, Matt Cardone and Brian Myers and Mark Sterling, those guys, they're the ones that know way more about any of that than I ever would, but happy to try to help. You can reach me at Gimmick Attorney on Twitter. Same thing for Instagram, or go to gimmickattorney.com and you'll find my professional bio and all the ways to reach me. And that's it. That's it for episode 8. This is Mike Dockins signing off for another episode. Thanks, everybody.